Welcome to another Wimbledon video on consumer law. Today we're going to be looking at contracts. A contract is an agreement that is legally binding and enforceable. There are 7 factors that an agreement needs to have before it can be called a contract. These are an intention, an offer, an acceptance of offer, consideration or reliance, capacity to contract, validity to contract, and legality to contract. Let's start by looking at intention. This simply means both parties need to intend to create an agreement that is legally binding. For example, students will often say to me, "Hey sir, you got to give me a merit if I get this in at the basketball court." That's not the same as you paying for a service, for example. Next, an offer. An offer is usually made by words, but can also be made by behavior. For example, by offering 2 tickets to something. You're offering to go into a contract with someone. Acceptance means literally accepting that offer. It can be verbal, it can be signing a document, or it can be accepting a ticket that's offered to you. Consideration is a little more involved than that. Consideration is the idea that a contract is only complete when a benefit has gone from one party to the other. And court cases have shown that this benefit needs to be at least of some value. On top of this, if a benefit has gone from one party to the other and the other party doesn't reciprocate, then you're allowed to say there was reliance on the contract from the other party and therefore compensation is allowed to be given. Next, we have capacity to contract. This basically means the person signing the contract needed to have the capacity to understand what the contract was and what it meant. Therefore, minors usually have to have parents or guardians sign contracts on their behalf. Also, people of unsound mind are not allowed to sign contracts, or if they do, they're null and void. And that's the same if you're under the influence of alcohol or drugs. Next, we have legality to contract. This is a simple one. A contract's unlawful if it contravenes public policy, for example, if you're facilitating a criminal act, or even an immoral one. And finally, validity to contract. This revolves solely around the idea that consent needs to be given. This consent must be given by both parties, free of misrepresentation, mistake, or obviously undue influence or duress. If your agreement has all of these factors, then it is a legally binding and enforceable contract. This is a quick look at what factors are needed for an agreement to be called a contract. If you enjoyed this video or found it informative, feel free to click on one of the links above to have a look at some other videos on my channel. And don't forget to subscribe to Wimbledon.